Good evening, everyone. My name is Karabo Ozah. I am the Director of the Center for Child Law at the University of Pretoria. Thank you for the opportunity to be part of your meeting. Unfortunately, I had to send a video because I'm concerned that I might not be able to connect during the time of the live discussion, as I will have load shedding where I live, and unfortunately, I don't have backup power. So in order to at least still contribute to the discussion I'm sending this video, I will try to see if I can still connect maybe on my phone and maybe answer any questions that may arise based on what I'm sharing with you. Thank you to the organizers for the opportunity not only to be here today, but for us to contribute to your guidelines. They gave us a moment to pause about these issues of consent and the ages of consent is provided for in the Children's Act, but also to think about how there is a need to do more research and to publish more in relation to the issues of autonomy and consent by children as they grow older, and also, to get to a point where issues that pertain to gender and is discussed in the guidelines, we begin to destigmatize them. At the center where we had a few cases where we had to intervene for children who identified as a different gender, and we don't have enough policies that support them in our communities. We don't have enough policies that support them in schools, and there is a need for better development here. But I'm at least encouraged that we have such thorough medical health guidelines for assisting obviously everybody, but particularly for our interest, children. So in line with the brief that I was given and the contribution we made to the guidelines, I'm going to just touch on Section 129 of the Children's Act, because that's the section that provides to the issue of consent, and it provides for when a child can consent to his or her or their medical treatment, also their surgical operation. And also, something that towards the end we need to maybe start looking at is obviously what gets done if there are conflicts in relation to what children want versus what their parents want. The guidelines do obviously promote a very collaborative approach that is indeed very sound, as children live as part of families and children are also part of communities. However, there may be instances where one is left with no option but to try and do what is in the best interest of the child, which might not be aligned with what is in the best interest of the parents, the guardians, or the adults who the child lives with or who look after the child. Anyway, to just get us started, Section 129.2 provides that children who are older than 12 are of sufficient maturity and mental capacity to consent, to understand the benefits and risks of and implications of treatment. They are able to give their own consent. So the age is the one leg of it, and then they should be able to understand the benefits, risks, social and other implications of that treatment. Now, one of the things that was crucial to make clear in relation to this aspect of the guidelines was what does whether the issue of mental health is also captured under the definition of health treatment, and we submit that in terms of Section 27 of our Constitution, also read together with a lot of international law treaties, and even the Special Rapporteur on the Right to Health report a few years ago confirmed that access to psychological and mental health services is a central part of the right to health. So that is a very important starting point to make it clear. And then we move on to then the fact that obviously children under 12 are not permitted or allowed in terms of the law to give their own consent. They will always need parental consent or guardian's consent in terms of the law, as well as children who may have some mental health impairments. They will always, even where they are over 12, they will always need that added support. Okay, so then what we also want to highlight, which I also already kind of touched on, is actually the fact that where there are disputes in relation to legal guardians' interests and where they may feel that children should not be allowed or should not go through certain treatment, And there are provisions in the Children's Act that provide for how the best interest of the child should be the guiding principle that is applied. In some cases, that may mean that where you do have a dispute in relation to particularly children over 12, in relation to the context we're talking about, they may have to be assisted to approach a court to then challenge the decision of their parents. I also want to mention that obviously in relation to section 129.10, being used a lot where parents also don't want children to get treatment for religious beliefs and also those kind of reasons. And there's been a number of cases where the court said that they didn't agree with the parents, because one of the requirements is that if you are saying that my belief is this, you must then indicate how you're going to have an acceptable alternative for dealing with a child. For instance, in this very specific context, which is, we know, a very complicated one, if somebody says, well, I will take my child to church and they will pray for my child and that will be the end of it, you know, the court may have to interrogate what does that entail and whether that is an acceptable alternative. I'll come back to this this issue of the courts actually deciding on this on these aspects, because they are very interesting views from other courts in the world about whether actually judges are best placed sometimes to be the ones to decide whether children must undergo certain procedures or not, particularly when it comes to the gender reaffirming treatment and surgeries and all that. But I will come back to that a bit later. So as I've already mentioned, the guidelines are very are written in a very measured approach of promoting a collaborative, you know, working with the family and the child and ensuring that the child understands, as we said, the risks and benefits as they decide or as they're being assisted by mental health practitioners. Firstly, you know, through the process, and then you do get to a point where then you have to deal with the issue of consent, where it comes to other aspects that may be a bit more complicated, and that is when you have to deal with issues of whether then you should, the 12-year-old upwards should then be allowed to maybe start taking hormone suppressing treatment, and those aspects are also aspects that have been covered in the guidelines and fall under the definition of medical treatment. So it should be that if a child is then over 12 and has the maturity to understand the risks and benefits and also the social and other implications of it, that there shouldn't be any obstacle to them being allowed to continue with that treatment. And obviously, from my understanding of what medical health practitioners and the mental health practitioners do, this is a very intense, ongoing process. It's not something that one decides overnight that it is done. And that is a very child-friendly and child-centered approach that also links with what the law wants us to do when it comes to respecting the autonomy of adolescents as they grow, is that you must start giving them space to express themselves and work with what they want to get from the process. Okay. It gets a bit more complicated, obviously, when it gets to the issue of whether the adolescents should then be allowed to consent to their own surgery. Remember, we go back to section 129.3, which says that they can consent, but they need parental consent as well. And that is where we foresee that, you know, in the future, you might have a lot of challenges in relation to this, and it might be where, for instance, you end up in court. But, you know, again, the guidelines say that, you know, there should be an approach that allows a multidisciplinary team to actually engage with the adolescent and engage with their family, and then decide on the best way forward. I would emphasize that, again, this is a process that's very prudent. Obviously, if there would be a dispute then in relation to an adolescent, certain that they want to undergo gender reassignment surgery, there would be and their parents do not agree with their views, then that would be a situation that may end up in litigation. It has not come. Maybe one day it will come in South Africa. Okay, so I think, you know, from my side, the South African law is clear as set out. There's been not enough written on some aspects of Section 129, mainly probably because there hasn't been a lot of disputes that have led to people going to court. As I said, the most prolific kind of short judgments you will get is in relation to the issue of blood transfusion, because people are Jehovah's Witnesses, or people believe that they can take their children to a traditional healer to cure cancer. We've been involved with those kind of cases, but there hasn't been particular cases in relation to these issues that go to the autonomy of adolescents and might, you know, sometimes not be aligned to what parents think should happen in relation to their children, and particularly the idea that then they would be doing something that is permanent and cannot be reversed. So that is something that obviously there's space for a lot of research, there's space for a lot of thinking around that, and obviously until a case comes, one cannot know how that case will go, because each case will be decided on its facts. As I mentioned earlier, we're still quite behind in relation to other policies, such as you know, school policies. I think Western Cape is the only province that has a policy that accommodates the needs of children who identified in different gender, and makes provision for how they should be accommodated, while the other provinces in the country more or less ignores it. I haven't seen a clear national policy in this regard. So, you know, there is a need to also think about that, because as mental health practitioners and as doctors, medical practitioners, you're providing your services not in a silo. These children live within a community and space that is not conducive for them. That creates problems, and that's something that I'm interested in looking at in relation to how other policies also need to be reviewed to accommodate that. I wanted to share just a quick example about a UK judgment, but also something that I read what a UK lawmaker was saying the other day, which is that this person said that because children have no right to change their gender until they are 18, they have no right to then request or demand that they be accommodated. For instance, the person said it doesn't matter that they want to go into the boys or what is seen as the boys or the girls' toilet, they shouldn't be allowed because they don't have any right to alter their gender until they're 18. So that's the kind of environment that adolescents and children will find themselves, and you know, people should be thinking about the harm that that kind of environment does, versus, you know, taking steps that accommodate them. I'm not saying it's always a very easy approach. We had a case where a child was in a boarding school and started identifying as a different gender and wanted to be put in the hostel with the gender that they identified with. And the school refused point blank. And at one point, then the parents decided, together with the child, that it's best that she comes home and takes the bus every day to school, because the school was just not budging. What we tried to do there at least was to organize a workshop for the school to educate them, an educative workshop, the issues pertaining to gender. I don't know what impact is made, but it was quite said that there was no room for movement in accommodating that learner. We also understand that it's not an easy thing. We still need to work with our communities, and that's also very important, to destigmatize and actually educate people about the issues we're discussing tonight, because we may understand them and we may be comfortable to deal with the issues and accommodate everyone. But unfortunately, most of our societies, not only South Africa, generally in the world, there's still quite a very conservative approach to these issues. Lastly, I wanted to share with you a judgment that may be encouraging to you as medical practitioners and healthcare practitioners. I don't know if you're familiar, there was actually litigation in the UK where a person who is now an adult, who was 16 when she started taking hormone suppressing medication, did that and transitioned from being female to male, and later decided that the decision was wrong. And then this person then took an organization that was supporting her throughout that process when she was an adolescent. She took them to court, saying that they were not careful enough when they took her to that process, and that actually they should have approached the court to get a court order allowing them to give her the treatment, right? So then this went to the first level of the court, and the court said, yes, they agree that actually the organization and the medical practitioners were wrong. They should have come to court. And then also the court issued what they called guidelines for how going forward organizations and medical practitioners should actually deal with this issue. I will share the judgment with Alma so she can share with everyone who's interested in reading it. And then this now went to the Court of Appeal, and the Court of Appeal said that they didn't agree with the previous court. Very, very importantly, obviously, they go into the issue of how this process works. And the process works in such a way that the mental health practitioners and the medical practitioners are the people who work with the adolescent and advise them and do a thorough process. And the court said that the court is not the best place decision maker in this regard, and that you cannot expect that in every case where an adolescent wants to start hormone suppressing treatment, that an organization or somebody must bring a court application and get consent, and that will be burdensome, and that will actually undermine the whole process that the medical practitioners have taken and are taking in line with what the adolescent has presented to them and has said that they want. This aspect is very important because, as I say, it affirms obviously the role of the medical practitioners and the respect for their role in this, but also, it also, as much as the person here changed her mind later, it also shows how the court also in a way respects the decision that she took then. So you were 16, you took the decision with the information you were informed with now at that time, so you can't come now and change your mind in this way. And I think it would have been a tragedy if the court had said that, she didn't have the capacity to consent at that time, or that she could have been counseled better or something like that, because that would mean that it would have undermined the autonomy that most of our laws in the world are starting to recognize, the autonomy that's given to adolescents. So I think it's a very good judgment. And then lastly, the very important aspect, which you're more familiar with than me in South Africa, is that our colleagues, the lawyers, are always suing medical practitioners, and they just say that medical practitioners dealing with these issues will be very alive to the fact that they can be sued and that there can be civil claims against them, and they doubt that they will just take a haphazard decision in relation to this aspect and what they advise an adolescent in relation to this process. And therefore, then the court emphasized that you couldn't have guidelines that say from today all medical practitioners must tick these 10 things before they allow an adolescent to start this hormone suppressing treatment, because you're taking away an individualized approach, which is central to what you all do. It's central to my work as well. We know our constitution says a child's best interest is the paramount, but it has been clearly set out that an individual child, you must always do a real life assessment of that particular child's best interest at that time that you're dealing with it. So I found this judgment very encouraging and very good. As I say, this space is not an easy space, developing a lot, and I think there's space for more research, for more collaboration, and also, looking at how the laws could also be improved to make the process easier for adolescents, but also equally for the healthcare practitioners that assist them. I hope this is useful, and all the best for the rest of the meeting. Thank you.
Already starting to have very, very interesting conversations in the chat. Apologies for everybody that had some issues with the sound. Unfortunately, we also realized that there is a bit of a challenge for people that's on their cell phones that won't be able to listen to the whole slideshow or the whole YouTube there. But at least we know there is some workarounds, and definitely afterwards for the people that want to go and listen to it, there is the possibility on our YouTube channel. But let's then move over to our first live presenter, and that is Dr. Michelle Carrihill. And I'm going to presume you're going to introduce yourself and tell us how wonderful you are. So I'm handing it over to Michelle. Thank you.
Thanks, Chris. I don't think so. But as I said earlier when I met everybody, I'm a pediatrician and endocrinologist, and I'm going to share my screen now to hopefully get this, I was going to say to hopefully get this PowerPoint up and running, because it tells us a little bit about, here we go, hopefully it's loading. Can you see that it's loading? There you go. Everybody, yay, okay, thank you. And I've just got to work out how to make it go forwards. All right, so this is my disclaimer, and as I said, I'm a pediatrician and an endocrinologist, and what happens in the world of pediatric endocrinology is that we get trained and we get experience in managing children who have early puberty and who have late puberty. We know how to do puberty induction, and we look after children born with differences in sex development and therefore needing to have hormone therapy later on through puberty. And with this experience, then we got exposed to individuals who were coming asking for help with gender-affirming healthcare. So that's really how I slid, and many of us slide into assisting with gender-affirming healthcare. I also, as another hat on my head, have an interest in research ethics and in applied medical ethics. So I do like to think about how we're doing the right thing as best as we can. And sometimes there is discord between the letter of the law and application of medical ethics. I also need to put in a disclaimer, I am not a legal expert, but because of that, I do lean on my colleagues who know the law very heavily at times. And in particular, there's a very helpful group at the Children's Institute who are always open to having a conversation and engaging with cases that challenge us. So what I thought as a way of sort of bringing the law into this meeting and into the case discussions, because you've just heard quite a lot, and I knew there was going to be some duplication, but I thought this is a better way maybe of showing how we apply some of those laws. So these are 4 case scenarios based on similar cases that we've looked after in reality, obviously with no identification. So let's take on a case of Lindy, who is a 12-year-old young lady who was assigned male at birth, and she is now having the onset of puberty and finding it extremely distressing. And she comes with her family, and her parents are completely on board to block this puberty because they've known their little girl since she was a toddler. And so that's a case that we might be faced with. Another one, and this is becoming one we've been seeing more and more frequently lately, is an example of Storm, who is a 15-year-old person who first came out as a gay girl and then realized that they are actually transmasculine and came out as transmasculine, and also had an assessment that they were autistic as well, so on the spectrum. And typical of many of our people we meet on a day-to-day basis in our gender-affirming clinics is they want testosterone, and they don't just want it now, they actually want it yesterday. And these parents sit across from us with eyes this wide. It's all new. They just want the best for their child. They want a happy child, but they are terrified and they just don't know what the right thing is to do. And certainly they don't think giving a testosterone injection right now is the right thing to do. A third case might be Pixie, a 13-year-old who's recently disclosed that they identify as a girl. Parents are divorced. Pixie lives with mum, and mum is scared, but is open to discussion. Father, who lives apart from them, is adamant that his child must just man up. And unfortunately, that's a very real scenario we also might be faced with. And then the last one I've brought to the table is Peter, who at 11 years old has woken up with breast development, is absolutely horrified, has always felt he was a boy, and he wants this all to go away. And his parents knew sort of they had a tomboyish daughter, but now faced with their child now saying that their son They don't know what to do. They're anxious about all the things they read about relating to the medication, and in particular, what they've read about infertility and the osteoporosis that has been published in the literature. So the discussion points I'm going to go through are going to sort of help us later on to talk a little bit about how we might approach consenting in these cases. So you've just heard a lot about the Children's Act. And so we have these rules that are helpful to guide us. But interestingly, in the words of our colleagues at that Child's Institute, is they're not harmonized. So it isn't as easy as, I'm sorry, our previous presenter might have made it out. It isn't that here's the letter of the law and you may follow the letter of the law and there's guidance on it. There are these 4 sets of legislations that we have to guide us. So as I said, the Children's Act, there's also the Mental Health Care Act, there's the National Health Act, and then of course our Constitution. So let's reflect, and I put this in its. So this slide is about the Children's Act, as I said, and as the previous speaker said, that a child may consent to his or her own medical treatment if they are over the age of 12 and importantly of sufficient maturity and has the mental capacity to understand the benefits, the risks, the social and other implications of the treatment. And as Oriane highlighted in the chat during that first meeting, is who gets to decide who is of mental capacity. And it boils down to that person who is sitting taking the consent across the table, and you are in a team, hopefully, and the team was on board, but ultimately it does come down to the clinicians in most cases. And you know, as somebody who works a lot with adolescents, I'm very mindful of the fact that the adolescent's brain is still very much developing, and an important part of adolescent brain development, integral to how they develop as an individual in the world and how they step out into the world and take the appropriate risks to move away from that family nest. Integral is the stage of development where the immediate reward overrules the consequences in the future of potential harm. They understand the potential harm, potentially, but like I said, that immediate reward is actually what drives the decision. And now that may or may not be a good thing, but it's just important to note it. So when we discuss a treatment option with a person and their family, firstly, us as doctors may not know all of the potential implications to that treatment. We obviously know the indications and the side effects that we know about and potential complications and how we mitigate for those potential complications. But there are some things that we can't state with certainty will or will not occur. And fertility is an important one with this. So in instances of blocking an assigned female at birth, can we 100% say that this is a reversible decision, and that if this person later on wants to retain their own biological fertility, that they can stop blockers, stop hormones, and regain fertility? It's certainly been done, and there's lovely reports in the social literature, mostly of people who have done exactly that. But we can't say with certainty, especially because we are dealing with individuals where we are blocking them at TANA 2 or early TANA 3 stage of puberty, where there hasn't been that full induction of their gonads. So we can't necessarily say that they will be able to have a reversible effect on their fertility. And the same is true for individuals born and assigned as male. Those testes, gonads, are not going to be under the maturation of a gonadal trophic axis. The LH and FSH stimulation is not going to be there, and they are not going to get that spermatogenesis going that would render them potentially fertile. Now, if we wanted to try and harvest sperm, or potentially in the future, if they decide later on that they do want to attempt fertility and stop their hormone therapy, we cannot say that that's irreversible. And in fact, we may edge towards saying it's a non-reversible decision. So we can inform and we can guide on those facts, but the person making that decision for their own body, their own autonomy, this 12-year-old going on, is sitting with that adolescent developmental brain where today's decision and today's reward of this gender-affirming healthcare is a stronger reward that will potentially overrule that decision of what this might have on my fertility later on. So when we're having this conversation with the family, and especially, the parents, and we're saying, this is the case, the parents are often sitting about those future grandchildren that they're not going to be seeing. And of course, we have to be mindful that we are sitting with this child in context. Saying that, the next part of the discussion is that we do have to take that person's autonomy into account. We do have to take them as this is their body and this is what they want. And a healthy, live person who is affirmed now, rather than a potentially fertile but very unwell, sad, depressed person in the future. I'd much rather have that happy person, and we can deal with the fertility consequences later on if possible. But the law, again, going back to the law, now there's you've heard of section 129 of the Healthcare of the Children's Act, but section 31 very much highlights that any decisions, major decisions, and this would be called a major decision, any major decision made on behalf or with the child has to take into account the context of the child in their family and in society. And I've highlighted that. So if it significantly changes or has an adverse event on the child's living conditions, education, health, personal relations with the parent or family member, or in generally the child's well-being, we have to bear this in mind. And we have to, it's part of the law, it's written down, but also it's part of how we should behave. We have to take into account that parents' thought processes around their children. Not to say that the parents would be right or would be allowed to overrule what the child has asked for, but we have to bear it in mind and we have to address their concerns. And if we don't, we are going to be doomed to failing both that individual child and the child in context of the family. So, as was emphasized, the best interests of the child is paramount. So all matters will be around the best interest of the child. And who's to decide that? Well, again, it's the team of us with the child at the center. And there are standards that are then put out for the best interests of the child. And again, it's a very long, busy page, but I've just got it there for you to refer to. And it is open to an individual, whether a lawyer, a doctor, a parent, a child, or advocates in any other realm. It's open to emphasizing in different levels. So one might choose to emphasize the child's physical and emotional security. Another person might choose to emphasize the child's remain in care of the parent and family. So as many things in law, it has to be individualized to that individual and individualized to the context. And I think the most important emphasis is that it is a discussion, that decisions don't necessarily need to be made in one day, in one session, overnight, and that I'm sure Simon is going to be, again, highlighting this, is really the discussion should be about getting everybody around the table and everybody in some form of agreement that we are going on the right path for that person. So those 4 cases I put up, I don't think any of us would have any difficulty sitting with Lindy and Lindy's family and explaining the blockers. They are happy to have the blockers, explaining the blockers, side effects, everything, why we're using it, and then saying later on this is how we would consider introducing cross-hormone therapy and discuss the guidelines around them, discuss the timing and all of those. And that would be a reasonably pleasant conversation to be having with everybody concerned, I think. Saying that, I do have an individual patient who I've looked after since they were 3, and they're now a later adolescent. And even though the family looked after and loved this child as the gender they experience, at the time of cross-hormone therapy, the mother fell apart. Because even though there's been support and regular input, there's still that grief and that loss of the child that was, and in this instance, the child that fertility that might have been. So there's a lot of support, and from an endocrinologist point of view, I lean heavily on our mental health care providers to help support us and the child and the family. But coming to Storm, for example, Storm wants treatment and wants treatment now. And one can completely understand that they've come to this decision, and many of us in any aspects in our life, once we've made, we've mulled over something and pondered it, once we've made that decision, we want to act on it now and go forward. In this case, I think we have to hear the family, and we have to talk them and walk them through why we advise the treatment, why we work with Storm and work with Storm's gender experience. And we may discuss with Storm what are the issues that make them so uncomfortable with themselves, and is there a treatment that we can offer there rather than immediately rushing in with testosterone. But eventually it's really about discussing with the family and explaining who Storm is and how we can assist Storm going forwards. Pixie, in this instance, I've tried to make it sound as bad as it can be, but in this instance, if Pixie lives with mum, it's sitting with mum, and dad, who says his child must just man up, is dad not part of the scene? Actually, Pixie's health is around Pixie and Pixie's mum in this instance, and if dad isn't contributing financially, isn't contributing emotionally and socially, actually the law says he must be involved and informed, but he doesn't have to be the decision maker, and one parent can assist. And in fact, Pixie's the person who's the decision maker, but supported and affirmed by mum. And in Peter, in this instance, it is a very careful, considerate discussion with the family, who are shocked at this new disclosure, and it is a supportive process. And because Peter is young and 11 years of age, I've made that age, the parents are going to be the ones who have to consent to this care. And we have to be very careful at explaining gently but firmly why it would be helpful to Peter to not go through the puberty that they're currently experiencing, because he is not going to be happy with those changes. So I'm going to leave it sort of on this last slide of sort of the generic advice with this Child Institute, who kind of nicely puts it in quotations: how to avoid conflict and decide as quickly as possible, but within the reasonable time that you need. Counsel and mediate, and many times it's counsel and mediate again. As I said, individualize the approach within the context of that child and family. And the informed is very much informed. It's about the costs. We can't force somebody to pay if they dissent. It's about all of the aspects that we know and some of those that we don't know. And again, best interests of the child is the paramount. And then just sort of, I hate being a defensive practitioner, and I tend not to be. I just think it's important for everybody's care, including the child, to keep good notes and records about what we've said, so that you can revisit and you say, as per last visit, we spoke about this side effect, how you're doing with that, and taking it through. Revisiting some of the issues again and again if need be. And unfortunately, fortunately in our instance, I'm not aware of any in our practice that have needed this, but there may be cases that come to requiring independent legal representation if we can't get through dissent. And that's everything I've got to say. Thank you very much. I'm going to stop sharing now.
Thank you, Michelle. And I think that was wonderfully informative. And I believe there will be a lot of questions in the end that we can share in the end. I know we are working with the idea of finalizing the presentations round about at 8:30, and then we can have a conversation after that. It seems we might be running a bit later, but I think this is a very important thing that we need to discuss and really tease out and get more understanding, because we also know that there are cases that's already going to court or people that's saying they're going to court with unhappiness. And this can have, in the end, obviously consequences on all of our practice. But I think, Michelle, your presentation was fantastic, and we got a lot of ideas there as well. Thank you very much. So I'm going to hand over then now to Simon, that's going to speak to us as well. But first, an introduction that Simon can do about themselves, and then also share all their knowledge and expertise. Thanks, Simon.
Sure. Well, thanks very much, Chris, for inviting me to be part of this discussion tonight. It's a little overwhelming listening because this topic is so crucial to me, and I am so worried about what's happening in South Africa, and if we're about to go off the deep end and make a lot of mistakes. Essentially, I've been working in this field for quite a long time. I came back to South Africa in 2010, had been working with transgender youth for about 10 years before that, and started a clinic at Red Cross. And having gone from one patient every 6 months, I'm now sort of getting 3 referrals a week. And for me, it's totally unethical not to involve the parents. And I'm not quite sure where everybody is in on this sort of group discussion, because I certainly see patients, young people, who have been consented to hormones without even one of the parents being there, or necessarily both of them being there. And unfortunately, I see this as a complete lack of understanding of child development and how they fit in the family. And certainly some of what Michelle pointed out is really helpful in the law of young people needing to understand the benefits and risks of social and other implications, because children exist within a family. Arguably, young people up to 25 or even later exist within a family, and it is so important. The literature is very clear. These young people do so much better if they have the support of their parents in particular. If they don't, on their transgender journey of transitioning both socially and physically, they have very poor outcomes in comparison to those that do have support from parents. So in my mind, it's not just about the law, it's really about ethics, and it's also about guidelines, which we need to constantly remind ourselves. In my understanding, the guidelines are very clear. We need to work as a multidisciplinary team, and the first person involved is a mental health practitioner. And there are very good reasons for this, because in my experience working with this population, 98% of parents can be completely on board within 3 months at the absolute maximum. I have almost never had a parent that hasn't come on board, and for that 2%, I've seen over 150 of these young people and worked with them, and always both parents, unless one is dead. I pretty much insist they're there. We get them on Zoom, we get them to leave their offices and come and join us, because so many families think that dads are not necessary, but invariably dad's the person you actually need in the room most. So I presented at the UCT day on just a few days ago, and in some ways I wish I could give that whole presentation tonight so that people can understand how one can get parents invariably on board. One also needs to look at what are the ethics. Yes, it might take a bit longer, but what are the ethics of leaving parents behind, because the outcome longer term, in the short, medium and longer term, are so much worse if parents aren't on board with their child's decision. I just want to show you what I'm talking about when I talk about this, because some people will say, well, we don't have the resources. How can we do this? The truth is that I think everybody can do this. It's not only me who can take this sort of history. Can people see my slides now? Chris, can you just let me know?
100% yes, thanks, Simon.
Okay, well, I'm not going to take you through everything, but I want to take you through just one or two slides. So, as I say, my belief is mental health people and practitioners who are trained appropriately and who learn how to do this could learn how to do this fairly quickly. But it does need a mental health practitioner because they have certain skills, also somebody with skills with working with children and adolescents. So this does not include GPs. It might include pediatricians or therapists if they have skills in working with young people, and they could be trained up those that don't. So first of all, there's an evaluation of the transgender young person where, as I said, it's so important to have both parents there, because when one makes a decision on changing one's body, that is a far bigger decision than contraception for the next few months, because a lot of people say, well, if you can make your decision about contraception, why not, also your body? Essentially, dad needs to be there as well as mom, because both parents need to fully understand all the implications. And I think we particularly need to think of paternalism. Many of us grew up in an environment where the doctor told you what to do. Particularly in this area, it is not our decision as the mental health practitioner or the endocrinologist to make a decision for a child. In my view, it is the child and the family that should make the decision, but our job is to give them all the information to make the best decision. So firstly, in evaluation, I want to know, what does the young person actually want? That is extremely important. Also, we want to know what coexisting conditions might be there, particularly autism, because autistic young people think very black and white. They sometimes have no clue that essentially coming home with a beard might cause an absolute disaster in terms of their kind of relationship with dad. And I've seen that. So we have to take into account, a situation, and 80% of the youth I see also have coexisting autism spectrum. Very importantly, the evaluation is to help the parents or carers understand how best to support their transgender child. So, in terms of what this evaluation looks like, I first take a history from the parents with the child present, and then see the child on their own. Now, the child on their own will give me a gender history in about 20 minutes, extremely accurately, because they're abnormally advanced in understanding transgender and what they need for a good outcome for their bodies. But that is not the whole context. The broader context is their family, as Michelle pointed out, and it is not always clear their understanding of the context, but actually I would argue it doesn't matter. One's role as the mental health provider is to help the parents understand that what the child is asking for is actually evidence-based and in their best interest. So while a GP might be able to sit with a child and in half an hour establish that they completely have capacity to make consent to take hormones, frankly, all the work needs to be done with the parents, because unless parents are on board, the wider context is that there's going to be a rift created between this child and their parents going forward that is going to be incredibly damaging. Of course, there is a timeline, but I would argue if one can do that and 95% of the parents at the end of my one assessment, but it does take 3 to 5 hours, the extra 2 hours are if they have autism spectrum, which maybe most clinicians don't have the ability to see necessarily, but maybe they could at least refer them on if they're thinking about that. But at least it does take 3 hours. But in those 3 hours, if one can get 95% of parents on board, then I think it's totally unethical not to at least try. So after taking a history, I feed back to parents what I'm seeing, which invariably is, yes, your child is past Hannah stage 2 of puberty, which is the point at which 90% will never lose the wish to be the opposite sex. And then I give psychoeducation, which takes at least an hour of discussing what does and doesn't help. And very briefly, I take them through what we used to do, which is not do anything before 18, and essentially that the outcome is pretty disastrous if we do that and wait for later in life to have gender affirming changes. And then I explain the development of the Dutch protocol and essentially of giving hormone blockers at a point where we know this wish is highly unlikely to go away, and then cross-sex hormones. And they completely compelling positive outcomes. And I give them various other facts that it's not the parents' fault, that we almost certainly know that there's a biological link and probably the brain is more of a brain of the opposite sex. Having gone through that psychoeducation, as I say, parents might well feel, upset about things. They might need to mourn the loss of having a gender typical child that they thought they had. But 95% of them are completely behind their child's decision. And our job as a mental health practitioner, as Michelle said, is to put the parents who do have difficulties with this in touch with, support groups or whatever is needed. I've had 1 or 2 parents who do need more time, and I would say the mental health practitioner's job is to pull the child back who wants the changes yesterday and to help them see that they've had 3 years or 10 years or 15 years to figure this out, but their parents need a bit of time. And that's where the insight is important of understanding that waiting another 3 months, unless the voice is literally breaking, which it rarely is that you get in the middle of that actually it's worth them waiting another 3 months and empathizing with how difficult it might be, but actually to get both parents on board is going to really have a very positive impact in their future. And as I say, I've almost never had a parent who's never come on board. So I think people are worried about things potentially going wrong, but I firmly believe that if this is done in a way that brings parents on board, helps them feel included from the beginning, and doesn't leave one of the parents out. Many times there are split up parents and one parent is more open and ready to accept the child. It's crucial to get the other child, the more skeptical parent in the room, to come on board and be given all the facts. They rarely don't. I do have one. Oh, the other thing I wanted to say is that what's happened in South Africa to date happened in the States a while ago, as in gender affirmative care has been around in the States for quite some time now. But what we've unfortunately seen is clinicians who are not trained to have these discussions with parents or understand autism or understand child development are just consenting young people perhaps without one parent or both parents occasionally, or much against parents' wishes, saying things like, well, if you don't consent to this, your child could be dead by 18, and not going through why it's important. And this is giving gender affirmative care a really bad name. So I really hope in South Africa we can stay aware of this and not rush through the consenting process, but involve parents from the beginning and realize how crucial their support is for each gender diverse child. And in fact, with all of Michelle's examples, I would give all 4 of those sets of parents, exactly the same information around transgender health, because even the last one, they need to be talked through that, because parents find it incredibly helpful understanding the whole area. Obviously, one specific at some point about their child fitting in exactly how they are, but you know, unfortunately, it's not a quick half hour, even an hour. It does take 2 or 3 hours. Most of my clients, I always ask them, would you like to come back? Is this getting too long? No, they all want it to hear the whole thing and to go through the history, feedback and psychoeducation in one session, because otherwise they find it difficult to hold the pieces together. And of course, they can come back and ask again. But I'm going to stop there because I think we are getting on for time.
Thank you very much, Simon. Always a fantastic presentation. And I think we can now already start to hear that we have a diversity of opinions in this area. We have people that are very concerned about family participation. We have people that are very more open to the idea of, no, if one parent is on board and the other person has been informed, and then we go right through to the other section where we get people that say, well, if a child can consent over the age of 12, why shouldn't they get hormones? And I mean, that would be more of our radical groups that works with an inclusive kind of idea, of rights-based idea. But where is the ethical point for all of us to practice? And I see already there is this kind of idea, but is it 18? Is it 25 when the brain is really developed? What is the legal ideas around that? And maybe that we can discuss again next time, because I think there's already a need being shown here tonight, that maybe we need to then also bring in our people over 18 next time. But I think for tonight, if it's okay with everybody, let's keep it with people under 18. And we'll start discussing that. But I do know we have another speaker, and we have been chatting so a little bit on the other side as well. So I am going to introduce Jenna Lee to tell us what they will be presenting next time when we meet up, because there we have the vulnerable adult coming in. So Jenna Lee, I'm going to hand it over to you for 2 or 3 minutes, and then we're going to go into questions and answers and discussions. Thanks.
Sure. Part of tonight I was going to present on people, and specifically adults with intellectual and developmental disabilities. But yeah, we want to give that the time and the consideration that it needs, as well as time for the discussion and the debate that's happening now to continue. But yeah, I think it touches on very similar issues to what is being raised in the chat, because I think a lot of it comes down to capacity, and how we assess capacity and what we consider capacity to be. And yeah, so that is what I'd be talking about more, but in the context of intellectual disability. And essentially it is that informed consent it's not a decision, but it's a process. And that process needs to include the entire system. And especially for people with ID, they're so dependent on other people to be able to access healthcare, that if those people aren't they're not on board, then they're not going to access the healthcare that they need. So it's essential to include them. But yeah, in terms of capacity being a process, it also means that we have to assume that somebody does have capacity until proven otherwise. And you can only prove that the person doesn't have capacity if you've given them the maximum support that they would need to be able to make an informed decision. So I'll be going more in that, and specifically what kind of accommodations can be used for people with intellectual disability.
Thanks for that, Jenny, and thank you for being so willing to place that on ice for us until next time, because I think we already have so many questions here and so many ideas.